I'd like to go ahead and thank everybody for attending. This is the LG webinar series for May 11th, 2022. Our topic for today is branding concerns from trademark, licensing, and litigation perspectives. Speaking today is myself, Kevin Thompson, as well as Joseph LaPlaca and Roenan Patt. So I'd like to thank everybody for attending. If you have any questions, please feel free to raise them through the chat system, and we'll take questions throughout as appropriate. At the very least, we'll have time at the end for questions. So feel free. Those of you watching the recording, feel free to email us later with your questions. If you want to go to the next slide. Just a standard disclaimer, the materials presented today are for information purposes only and not for legal advice. So please keep that in mind as you review our webinar. So go next slide. Today's agenda, we're going to talk a little bit about just what is branding and some trademark perspectives on it. And then Joe is going to talk about licensing perspectives on branding. And then Ronan's going to talk about litigation perspectives on branding. So a little bit about myself. I'm the head of our practice group for intellectual property here. I've had a lot of experience, about 22 years of experience at different firms here in Chicago, dealing with trademark rights from around the world. So without further ado, we'll move on. So just, what is branding? Branding is the process of coming up with a way for your efforts to be well known. You think of a brand, you think of something like a Coca-Cola or a McDonald's, which through marketing has gotten distinctive consumer recognition. So next slide, please. From a trademark perspective, trademarks are symbols that are used in commerce to identify the source of particular goods or services. It could be a trademark on particular goods. It could be on particular services, but it's gets its start. Trademark law gets its start from the idea of consumer protection. The idea being that consumers need to know where particular goods or services come from, so they can compliment or complain depending on the nature of their inquiry. Next slide, please. What can be a trademark? And it can be all sorts of things. It can be a company name. It could be a URL for their website. Think of like an Amazon.com. Could be a design or a logo. Think of the golden arches for McDonald's. Could be a product name or a service name. Think Big Mac. Or a service. Again, think of like an Amazon for like online shopping. Slogan. If you think of a particular famous slogan, sort of like recognizing particular things, for that company. Trade dress, that could be the packaging for a particular product. People might recognize the Coca-Cola bottle as a particular trade dress application. Trade name. These company names can be trademarks, but they're not always. It really depends on how it's used. It's got to be used as a source identifying fashion as a trademark, and not just merely as the company name. And then some of the really fun ones that happen more these days are colors. Think pink for insulation, as Owens Corning. Sounds, the tones for NBC, the dun 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 for NBC, that's a registered trademark. And then there's other non-traditional trademarks, such as scents, that's starting to come into vogue. And so if you have any of those that you're interested in, let us know, and we can talk a little bit more about how that might affect you. So next slide, please. So when you're talking about branding, it's important to keep in mind that your trademark is sort of judged on a sliding scale in terms of how distinctive it is, just based on how it's formed. Um, so the um, uh, the descriptiveness starts at the highest level with the most level of distinctiveness would be a fanciful, a coined, or an arbitrary term. If you think of like a Kodak or an uh, Xerox, those were coined things. The an example of something that's arbitrary is something that is um, it's a well-known term in certain fields but not others. So Apple for computers, everybody knows what an Apple is, but outside of the context of computers, it's not suggestive or descriptive. It's a merely an arbitrary use of that word, which has gotten distinctiveness over time. Um, there is suggestive, where particular mark might uh, uh, to describe it, but not totally. So like chicken of the sea is suggestive. Doesn't really exactly tell you that it's tuna, um, but it's descriptive that it's something from the sea, and it's like chicken, but it's not chicken. Um, so some other things. Something that's merely descriptive is something like it just describes the particular product or service, um, such as Crunchy for crackers or Best Buy for shopping. It's something that Best Buy is something that sort of gained its um, it, through marketing and so forth. It gained distinctiveness, but it sort of started off as a descriptive use. And then there's generic, which is the lowest level. And something that's merely generic can never really be protected. Something as generic, something like uh, uh, aspirin is something that actually became generic. It was a trademark and lost its rights. Similarly for um, uh, escalator was originally a trademark owned by the Otis Elevator Company, and they didn't think of like an alternative name for it, and it sort of became the generic name for sort of a moving staircase. Um, so um, the next thing to keep in mind is when you're analyzing this, when we're doing clearance for a new brand, we always keep in mind the different factors that come from. There's a famous case, the DuPont case, where they enumerated 13 factors that they look at. The most common are the appearance, the sound, the commercial impression, similarity, the goods or services. Um, so um, uh, Here's the thing: Apple for computers coexisted for a long time with Apple for music, owned by the Beatles. Um, and they originally had worked out a coexistence agreement where Apple for computers would stay totally out of the music business, and we know how that happened. They ended up getting sued by the Beatles when they went into music because they violated their non-compete agreement, and Apple ended up paying a lot of money to the Beatles over that one. Um, Similarly of trade channels. So like how are the goods used? Are they how similar are the consumers? Are they sophisticated? Is the next factor. So if this is like an impulse buy, if it's something that you normally would just walk into a store and pick up, it's the trademarks don't have to be as close. But if it's a more sophisticated purchase, where it's like let's say it's $1 million X-ray machine, and it's a sophisticated, well thought out, well reasoned purchase, then the trademarks can be a little closer. Next slide. Some of the other factors are looked at as the fame of the prior mark, the nature and similar marks. If it's a crowded market, it's a little easier there for them to coexist. Whether or not there's any actual confusion, like evidence of consumer phone calls or something like that, where people reach out because they've been already confused. Whether it's a house mark, what we consider a house mark would be um, like a again a larger brand, um, and then to the extent in which the applicant has a right to exclude others, like if there's a particular agreement that they may have in place, again, sort of the Apple issue there we were talking about earlier. And whether or not there's any, the 13th factor is if there's some other unique fact on these circumstances that the court should take in mind. That's where they have a little bit of wiggle room there. So all in all, when you're doing branding, I think it's important to keep in mind, just how clear it is from others, and so that's why we analyze these likely to confusion factors. But to summarize, I think one of the more important things to look at is the prior chart where we talked about the distinctiveness scale, because the more distinctive it is, the easier it is to protect in the long run. If it's descriptive, it's much harder to gain rights in a particular field. So that's something we usually counsel people in when they're trying to decide between two marks. I'll usually err on the side of heading towards something a little more distinctive because, again, it's a lot easier to build up a brand that ultimately builds the consumer protection that you want, the consumer recognition. All right, so I think we're ready for our next speaker, which will be Joe LaPlaca. If you want to introduce yourself, Joe.
Thanks, Kevin, and thanks to everyone who is joining us today. My name is Joe LaPlaca. I've been at LG for close to 3 years now. My main focus is protecting LG's clients through risk management, specifically focusing on licensing agreements and meeting the interests of our clients. Today, I'm going to be talking about the licensing portion of this presentation, how it interplays with branding and how to protect your brands through contractual language and through licensing agreements. So some of the benefits of licensing agreements, obviously the first one, right, is it can increase your profit. So having your product or service licensed to another entity, it gets it out into the marketplace and can increase your profits. You spend less resources on marketing, production, and distribution, and sort of pass that off on a separate entity. Brand recognition is really important when it comes to licensing. You're able to distinguish your business from your competitors and other third-party businesses. And once you've licensed your product and service and it's effective, there becomes this customer reliance on that license to continue to use your product and service. Some of the risks included when thinking about licensing your brand, first and foremost is the ownership of your product and service. So that means the intellectual property rights. It means the copyright, patent, and trademark rights to your product and service. Another factor is control over who is authorized to use your product or service. And one way to do this is through an audit. And the only way to make sure that you have the ability to do that is through written contractual language that gives you that right to do so. Another concern is who has the availability to alter or improve your product or service. This is important when thinking about it. Is your product final when you license it? If it's not, if you want to continue to do work on it and improve it over the course of the license, that's something that should be contractually negotiated with you and the licensee. There, if the licensee chooses to make enhancements or improvements to the product, we need to know who has rights to those enhancements, and making sure that the ownership of the overall product stays with the licensor, and that way you protect your brand. Other factor to consider is third-party infringement. Who else is going to have access to your product and services? This is something that at the outset you might not consider thinking about, but there could be other parties who have access to your product and service through the licensee and through the inner workings of their business with the licensee. And the final risk to sort of consider is quality assurance, right? When your product goes into the market and you have total control over selling it, the quality may be higher than if you were to license it. But with that being said, you might have less profit because you're doing all the work on the front end to get that product to its consumers. So by way of illustration of how important license agreements can be and the terms that are included in those license agreements, I've included this case Baldwin Piano versus Deutsche Wurlitzer. So on the left we have a 1960s Baldwin piano, and on the right is a Wurlitzer jukebox. So this dispute arose from the terms in a license agreement, or lack thereof, as we'll find out. So the facts are as follows. So in 1985, the worldwide music brand Wurlitzer decided to break off into divisions. One of the divisions being Baldwin Piano, which would have Wurlitzer transferred it transferred its trademark name Wurlitzer to Baldwin Piano in order to use that trademark in their business. At the same time, they spun off Deutsche Wurlitzer to have a license. Deutsche Wurlitzer had a license to the trademark name Wurlitzer in order to put it on their jukeboxes. So that was all good in 1985, but the transfer of the trademark to Baldwin Piano gave Baldwin Piano the right to do with the trademark what they wanted. And when Baldwin Piano licensed it to Deutsche Wurlitzer, the license agreement did not include an end term of when the license was to end. So fast forward to 2003, Baldwin Piano tells Deutsche Wurlitzer that they can no longer use the Wurlitzer name on their jukeboxes, effectively shutting down their business, right? That's how they identified their jukeboxes. So what ended up happening was Deutsche Wurlitzer filed a lawsuit against, Baldwin Piano filed a lawsuit against Deutsche Wurlitzer, claiming an injunction to so that Deutsche Wurlitzer could no longer use the trademark on their jukeboxes. In turn, Deutsche Wurlitzer counterclaimed for unjust enrichment and abuse of power, as well as breach of contract against Baldwin Piano for not being able to use that trademark. So what the court ended up deciding in the Northern District of Illinois was that because there was no end term in the contract, and the contract simply said that this agreement shall continue in force without limit of period, but may be canceled by licensor for material breach, the court decided in the district court that they were going to go with the default rule that because there's no end term, that the agreement is at will. So therefore, Baldwin Piano at any time could pull the license out from under Deutsche Wurlitzer, and Deutsche Wurlitzer was basically just out of luck. So Deutsche Wurlitzer obviously didn't agree with that opinion, so they ended up appealing it to the Seventh Circuit. And at the Seventh Circuit decided, that businesses are not compelled to make sensible bargains, but courts should not demolish the economic basis of bargains that should be sound if the contract were given a natural reading. So what the Seventh Circuit decided was we should be more commercially reasonable and know that in 1985, when Deutsche Wurlitzer was given that license to use the trademark Wurlitzer on its jukeboxes, that it should really be a perpetual license and not end because they failed to include the essential term in their contract that it was a perpetual license and not default to the the provision that says it's an at-will contract and that Baldwin Piano could cancel at any time. So the Seventh Circuit issued that opinion, and then Deutsche Wurlitzer was again allowed to include the trademark on their jukeboxes. But that was a lot of time and a lot of litigation that all had to take place because the agreement between the parties, the license agreement specifically, did not set forth the end term. So some of the takeaways from this case, right, is that you need to include essential terms in your license agreement to avoid uncertainty of obligations. It's important when drafting the license agreements that the drafting is precise and it's unambiguous as to each party's obligation, and how long that obligation is going to last, the different factors that we discussed earlier, such as audit rights, giving notice to other parties on certain issues, and making sure that everything is in place so that way when and if disputes arise, they're quickly dismissed because of the terms of the contract telling the parties exactly who needs to do what. And just as a rule of thumb, usually the longer the term, the longer the contract, because you have to plan for, what could go wrong in the future and set forth those terms in the license agreement. And by way of example, the 18 years down the road, Baldwin Piano pulled the license from Deutsche Wurlitzer because they didn't have an end term in the license agreement to begin with. Other essential terms to include in your licensing agreement, especially to protect your brand and trademark, include, the restriction of the removal of any symbols or indications that this is your product and your trademark, preventing any challenge to ownership of your product or service, restricting the use to authorized users only of the product or service, making sure that your brand and the goodwill of your brand and trademark is going to be protected. So that way licensor cannot badmouth your brand or mislead anybody as to the services and product that you provide. And then non-disparagement clauses and limitations of liability and indemnification are equally as important to protect yourself should anything arise that's unexpected or should any litigation come up. But the biggest takeaway is that license agreements they need to set forth the obligations of the parties and include essential terms so that way everyone's on the same page and you can avoid litigation in the future that could be very costly and very time consuming. And with that, I'll turn it over to Roenan Patt.
Thanks, Joe. Hello, my name is Roenan Patt. I've been a litigation attorney for 10 years, and my area of experience is in business and commercial litigation, including unfair competition, practicing in state and federal court. And so my part of the presentation is to talk about litigation perspective with respect to the branding topic that we're talking about. Next slide, Joe. And so for this purpose of this, we're going to assume that you have a valid trademark and that what happens when you find out when someone's infringing on that mark. Next slide, Joe. So as everyone's generally aware, litigation can be an expensive endeavor. So what's the purpose of it? And it's protecting your brand. As Kevin was explaining earlier, you know, trademarks serve several purposes. You know, everyone recognizes very specific trademarks that they can identify with, like the Nike symbol with the swoosh. You know, there's things, and everyone knows when you say Nike, everyone knows what you're referring to. Trademarks provide advertisements, they identify it. Sometimes it also goes to the quality of the goods that, you know, they speak to, so they're worth protecting and they have value. Next slide, Joe. So if you find out that another business or an individual is infringing on your trademark, you know, what can you do? There's certain causes of action that you have under federal and state law. Cause of action could be for trademark infringement, for unfair competition, for trademark dilution. And a lot of these claims are codified in the Lanham Act and federal law, but also several states have their own state statutes or at least common law protections against unfair competition. And as Kevin had indicated earlier, the basis of this law stems from having fair competition between the parties. And you'll see that as we discuss the act, kind of how that plays into the language of it. Next slide. So in order to succeed on a claim for trademark infringement, as we discussed, we're going to assume you own a valid and legally protected trademark. And then the next step is that the infringer's use of the trademark in commerce causes a likelihood of confusion about the source of the product bearing the trademark. And that's where that common law perspective comes in about unfair competition in how not to mislead either consumers or to take some other business's work or product for your own product. That's where trademark law, that's where it's based off of, and you can see it is that protection in the statute. As Kevin discussed, you know, some of the factors that are going to be litigated over on the trademark dispute is the similarity between that trademark and the infringing one, you know, the proximity of the goods, the strength of the market, similarity in market and advertising. There's a case that was a while ago when someone had used Kodak, which everyone, you know, from a certain generation attributes to film. You know, when you said Kodak, that's just what you'd think of, but it was Kodak with respect to, I believe it was bicycles. And so it was a different type of product. And does that really, you know, that mark really infringe? But those are the type of factors that you're going to be arguing over when both sides are, you know, in litigation. Next slide, Joe. Part and parcel with the, you know, trademark infringement is also unfair competition under the Lanham Act, and use those typically, those type of cases involve misrepresentation of the nature of the origin of the goods, false advertising or other misrepresentations, and sometimes that's going to be brought by a competitor, sometimes that could be brought by a consumer. You know, many state, you know, in moving from federal law to state law, many states have, you know, consumer fraud acts that deal with situations like that. And an example that you could typically sometimes see in the marketplace is that one competitor of similar goods might advertise their goods as American made when in reality the goods are made overseas. And potentially that conduct could be actionable because it's a false designation of origin and could give you a competitive advantage. There's certainly a certain segment of consumers that make it a habit of purchasing American-made goods. It would be almost similar in the sense of like a restaurant, you know, pretending to be that they're a local restaurant and not part of a chain, but really they are. You know, there's a big movement, especially during the COVID pandemic, you know, to support local and not necessarily go to chain restaurants, but businesses that were really, really struggling and didn't have a fallback. And so if you advertise that you weren't, you know, you were a local business, but you really are part of a chain, stuff like that is what's protected under unfair competition. Next slide, Joe. You know, additionally, you have stuff like trademark dilution claims, and that's a little bit more specific with trademarks that are considered, you know, more famous or well known. An example was, you know, an example kind of is like Kodak, again, for, you know, a few years back when that was, you know, when you didn't have camera phones and stuff, but that's, you know, Kodak was synonymous with film. the Polaroid cameras, the film that was in disposable cameras, and another business using Kodak. It could be dilution because it's changing where it's if it's with a dissimilar product, is it taking away from Kodak's what people know Kodak is. But that's another cause of action you might have in the trademark unfair competition realm, is trademark dilution. So getting to the purpose of you found some type of infringement or unfair competition or dilution, and you're litigating, but why are you litigating? And at the 1,000-foot level, you're litigating to protect your brand, but also you're entitled to certain levels of damages. You're entitled to monetary damages, including profits received from the alleged infringer. In some circumstances, you could get treble damages. You can get attorney's fees and costs, again, under certain circumstances, and potentially also injunctive relief. And all of that, it's hopeful if you didn't get injunctive relief, but you got those type of damages. The purpose behind that, again, is while you're getting money for someone else's use of your brand, it's also to say, that person's more than likely not going to be using your trademark again, or unfairly competing, so that it levels the playing field. Next slide. So in the beginning, we were talking about what if you were someone who had a valid trademark, and what rights, what can you exercise under the Lanham Act or any type of state court claims that you could have. But what if you're the alleged infringer, and sometimes a business receives a letter saying, hey, your trademark is infringing on our trademark, and a demand to see, what it's being used on, profit, stuff like that. So, is always a smart course of action. You should always consult your attorney. Just because someone's claiming a trademark infringement, unfair competition, or another claim like that, doesn't mean that your business is guilty of that type of conduct. That's, if everyone just admitted that they're always guilty of it, that you wouldn't ever have any type of litigation or disputes. There are things where you might have viable defenses to protect your trademark. And that kind of gets into, that's why you consult your attorney, whether it's an unfair competition claim, trademark infringement. You need to evaluate, especially when it comes to a trademark, how valuable is that mark to your business? What does it add to it? And that's not something that you just do with your attorney, but also your business advisors. There's a circumstance, I've been involved in, where a client had a mark, and you're accused of trademark infringement, and realistically, the mark wasn't that critical to the business. That's not necessarily why they weren't coming there because of the mark. They weren't identifying with it. So, we're rebranding because it isn't that valuable. Conversely, if you had someone like Nike, and there's someone's making that claim against Nike, Nike would have a lot to protect in defending their brand. So they would, fight tooth and nail. But sometimes you have to determine whether it's worth the fight. Another alternative when you're the alleged infringer is, even if you have applicable defenses, some of the things that you want to do is consider, and this comes from another situation I had, is that it was two competing similar goods, similar marks, and had a prior business relationship that went sour. And during the course of litigation, the parties were able to sort of amend fences where, there wasn't as much infringement, and they each got a benefit from it. And that also could get into something like licensing, like Joe was talking about, as a way to resolve that. But that's another avenue, that it doesn't always just have to be fight. Sometimes there's a business solution. It just depends on how both parties want to work at it. But sometimes you shouldn't raise the white flag, and then sometimes, depending on it, if it's not that valuable to you, you might want to consider what's the best recourse, and that might be just a rebranding campaign. Next slide, Joe. So,
Alrighty. Yeah, I was just going to say, this will be the point. If you folks have questions, please go ahead and raise them in the chat, and we'll raise them with myself or Joe or Ronan. I did have one question, Ronan. while we're waiting to see if there's any questions. In this current era where we're sort of coming out of the pandemic, how are courts handling like the need for a preliminary injunction? Are they handling those in person? Are they handling those online?
It's, you know what, federal court, it's still pretty much via Zoom. Federal court, you know, they're doing video conference, at least in the Northern District. They're still doing either video conference or telephone conferences. I'm sure if the party, and the courthouses are open though, so I'm sure if the parties requested it to be in person, they would. But so far, it's still a status quo of doing things remotely, which, you know, has a, you know, some benefit to getting heard pretty quickly.
Very good. Give people another minute or so to, if they have questions, to type them in. Otherwise, I'd say if you do have questions, please feel free to email us later if anything arises. Okay, I think I'll go ahead and we'll end the webinar for now. And I'd like to thank everybody for attending and look for the recording to be posted online shortly. Thank you.
Thank you.